Hello, and thank you for joining us for the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of the Greater Toronto Area family law firm, Feldstein Family Law Group. Both myself and the entire firm practice exclusively family law in the province of Ontario. Today, our special guest is Jordan Dolgin. He's the founder and CEO of Dolgin Professional Corporation, a business law practice dedicated to helping entrepreneurs start, grow, and sell their businesses. He will be speaking with us about the various aspects of business law and how they apply to family-owned businesses, also known as closely held corporations. So without further ado, Jordan, thank you for joining us today.
Andrew, thank you for having me. It's a pleasure, and I look forward to our discussion.
So I'd like to understand a little bit about what you do for your clients, because I mentioned that you help entrepreneurs start and grow their business. What does that mean, and what do you generally do for your clients?
Well, if you think of a business, as a legal person with a beginning and a middle and an end, my practice follows my clients, and my services assist my clients throughout the entire life cycle of starting a small business. It involves the initial steps of working with the clients, and there may be one, and often when a business gets started, there's more than one owner, and usually working with their other advisors, including their accountants, because tax issues are very important to consider. In the beginning, we're focused on structuring the new business and help it launch in a way that makes sense based on corporate, commercial, tax considerations. Then from there, the business will evolve and the business will grow. There will be all sorts of needs along the way as part of the growth of the business, whether it's bringing on employees, dealing with customers, dealing with suppliers, dealing with landlords, bankers, et cetera, all the relationships that are part of growing that business. And eventually, the business will come to an end. It will either, be shut down, it will be sold to a third party, and very often it gets sold internally to another partner. So it's really following the life cycle of the business as it starts, grows, and sells, really covers the scope of my practice.
So I try to look at it from a family law perspective, because I heard you talk about the start, the growth, and how much does family law play into it when you have clients come into your office at the start of the business?
Family law issues usually are not front and center unless the business is being started by spouses or other family members. If it's a business where there's no family involved, there still may be family law implications to the extent that one of the owners subsequently goes through a marital breakdown. And there's always concerns in that case about how family law might impact the ownership of someone's shares. But in a case where the business is started between family members, typically between spouses, in that case, the family law issues are more front and center from the beginning, as opposed to issues that get considered down the road.
So I guess there's a lot of probably myths that go into what clients are concerned about. And I'm going to take the first scenario you have, which is you have two partners start a business together. They're not related. And one partner is probably very worried when the other partner gets separated that they may end up finding themselves partners with the other person's spouse. Would that be a fair concern that you hear a lot about?
It is actually. And in fact, during the initial process of getting client instructions to prepare a shareholders agreement, often that very issue, Andrew, is discussed because there's this concern that if you and I start a business, you intend to be partners with me, and I intend to be partners with you. If it's possible legally at some future date that I may be partners with you and your spouse, that was not what I reasonably expected. And if that were to happen, I, as your partner, would like to know what the rules are so that that can be avoided.
Well, it's interesting because I know that that's a myth I've often heard of, and I underline the word myth because I believe I've been practicing now 26 years, and I have never seen that happen once in my 26 years of practice in family law.
Right. I would agree with that. It is among the list of unlikely. And as I've spent more time in my career and consulted with experts like you on, hey, Andrew, has this ever happened? As opposed to, could it happen? The answers I continually get is, I've never seen it. Now, that doesn't mean it couldn't happen based on an extreme circumstance with really unique facts. So it's prudent as a corporate lawyer to raise the issue and try to address it. But, is it in the realm of probable? It doesn't seem so.
Okay. The other thing that comes to mind that you said was about shareholders agreements. Perhaps you can explain what a shareholders agreement is to our viewers.
Shareholders agreement is really this tool that's used to manage the relationship among the owners of the business. And it's there to sort of change what the rules would be if there was no shareholders agreement and the corporate legislation governed the relationship. So, for example, there are a number of scenarios that even though corporate law has rules regarding director matters and shareholder matters, corporate law doesn't have detailed rules when it comes to what happens to a person's shares in the event that they were to die, or they become disabled, or they're terminated from the business, or they become incapacitated, or they become bankrupt. If that happened and there was no shareholders agreement, very often any buyout would have to either be negotiated or it would need to go before a judge. Whereas if there was a shareholders agreement that dealt with the scenario not covered by the statute, you at least have some operating rules to govern you and hopefully stay out of court and have a more efficient exit mechanism.
Now, I find it interesting because when I see shareholders agreements, I see them affecting family law in different ways that I think the corporate lawyers that have drafted them have never thought about it. Okay. One of the things I see shareholders agreements doing is prescribing a value to the business. It may be consistent with what the life insurance policy is, but there's values. And people haven't given any thought to the fact that when they're putting a value in a shareholders agreement, they may also be putting a value for family law purposes.
Right.
And I don't know if you do that in your agreements or if you have the discussion with the clients to make sure that they're aware that when they are placing this value, it can have negative consequences for them if they're trying to maintain the company does not have significant value.
Well, value is it's a highly important topic right up there at the top. Because if you think about a shareholders agreement in terms of its functionality, it really does two things at a high level. And this is the same whether we're talking about Ontario, Nebraska, or Japan. Shareholders agreement has rules which deal firstly with how decisions get made, or what I call corporate governance. And about half of most shareholders agreements have rules for the decision-making process. The other half of the shareholders agreement is what I call liquidity. It contains the rules for under what circumstances can I force a sale, or can someone force a sale on me? So when we're dealing with that part of the agreement that deals with liquidity, it begs the question, okay, now I'm forced to sell, or maybe I have the right to sell. What's the price? And what are the payment terms, and what are the other terms of sale? So valuation is key. And from your perspective, there are different ways that an agreement can approach value. The easiest and the most recommended approach is if the parties can't agree on the value, then everyone will bring in a third-party expert who's a valuator, a chartered business valuator, at least in Ontario. And we will have rules for a third-party independent valuation at the time we need a valuation. Some shareholders agreements try to say, hey, we don't want to spend money and time on a valuator. why don't we agree on a fixed price? Often in death, if there's life insurance and there's an insurance policy for $2 million, we could just agree. Once we get to $2 million, that's the price. Not a penny more, not a penny less. And I've also seen formulas. Sometimes agreements will try to have detailed formulas to get to a price, again, to avoid the expense of a valuator. So valuation is a key issue, Andrew.
Well, when I see that price on the life insurance policy, and I see, for example, I'll use your number of $2 million, and the person who's a shareholder going through the divorce saying the business is worth 200,000,
Right.
One of the things we're going to be attracted to is what the shareholders agreement said, because management knows best as to what they think the business is worth. So what I'm really getting at is you have to be careful when you're placing a value within a shareholders agreement, thinking it's for life insurance purposes, and you may get blindsided and find out you're separating 3 months later. It had much larger implications, especially if the timing of that is close to the separation.
Right.
The other place that I found it really interesting that you talked about was when you talked in terms of your liquidity and what to do when shareholders are in dispute, and it may give you a mechanism for how to buy out the other shareholders if you want to end the partnership.
Right.
The funny piece there that you see in a lot of shareholders agreements are shotgun provisions, and perhaps you want to explain what a shotgun provision is to everyone.
Shotgun provision is a provision that in theory is supposed to provide a efficient, fair way to break up the ownership group in circumstances where you're just not getting along. Nothing has happened. There's not a triggering event. It's not because of a death or a resignation or a termination. Both, in a simple example, with two owners that are just at the point of irreconcilable differences. And they just can't get along. But the other provisions in the shareholders agreement that might apply that are specific to an event, like a disability, can't be used. So nothing bad has happened. It's just we're not getting along. Is there a way to deal with that? And hence, lawyers have developed this mechanism called a shotgun, which is there to resolve irreconcilable differences. And often the way it works, if I use you and I as an example, is you're fed up with me. Under the agreement, you give me a piece of paper and I get to make a choice to either sell my shares to you or alternatively buy your shares. So that at the end of the process, whoever gets to choose, person receiving the offer gets to choose whether they're a buyer or a seller. And at the end of the process, we started with two, and now there's only one. Although I'd caution your listeners that a shotgun is not a perfect mechanism, except in the case where you and I are both healthy and active and capable of running the business without each other. And it can be used inappropriately. And we could talk for the full segment on shotgun, so I'll just leave it at that.
One thing I thought was missing in your explanation is that the person who decides to use the shotgun is the one that picks the price.
The person who initiates the shotgun gets to pick the price, the payment terms, and all of the other bells and whistles. It's just that it goes both ways. And hence supposed to be fair.
And the concern that I say to people when they come to me and they're starting a business and they're going through a separation and they tell me they're going to put a shotgun provision in a shareholders agreement, I turn around and say to them, and if you're going through this again where you're having another separation, you need to appreciate that if you're having a little bit of difficulty with your partner knows you're at a time of weakness when you're going through a separation financially. And it can be a great opportunity to utilize the shotgun and force the other person to sell to you because they may not be able to raise any money from anywhere. It's still risky, but you're in a point of weakness. And you need to think about it that if you're married, having a shotgun provision in a shareholders agreement can give a lot of power to the other side. Now, I do see that we had a question that I think is more aligned for you, Jordan, which is there a minimum percentage for the oppression remedy to be used?
Minimum in terms of?
I'm not sure. It's a question from one of our viewers. I assume it probably means shareholdings in the corporation. So is there a minimum percentage of shareholdings they need in order to utilize the oppression remedy?
No, the answer is no. There are some circumstances in the act where, you can only do certain things if you have a certain minimum. You need 5% to requisition a shareholders meeting, but not for oppression. Oppression is a remedy that will be available to a shareholder, even if they're not a voting shareholder. It's a very broad remedy, and it does not require a minimum threshold. All that it requires is that you qualify as a shareholder, and also that you have facts which have caused damages that are at law oppressive or unfairly disregards the interests of your interests.
And what I should add is that when the oppression remedy is going to be claimed between separating spouses, it will end up in the family court. Even if you try to start it in the commercial court, it will end up wanting to combine all of the matters to be in one court, and including the company as a party in terms of the oppression remedy. I'm going to go back for a minute to the shareholders agreement, because one other thing I've seen in the past that people need to be aware of is there can really be funny provisions that the shareholders, the first question I asked you was, do you sometimes see this paranoia that the other side's former spouse will end up as a partner in the company? And people sometimes put into shareholders agreements really aggressive clauses that if there's any litigation, they have to transfer their shares. And people need to really be thinking about those kinds of provisions at the time that they're making shareholders agreements, because you might think in 2020 your marriage is on solid ground. It may not be in 5 years.
Right. Well, it's interesting in my experience when it comes to companies where there is ownership among both spouses. Often that's done, and it's recommended by the accountants, whether it's for income splitting or whether it's for purposes of reducing taxes on sale. And there are cases where both spouses are really founders in the true sense, where their blood, sweat, and tears are directly involved in the business, as opposed to one spouse really running the business and the other spouse supporting the family, but not directly supporting the business. And those two situations are really different, and they're often, the product of the accountant. Often, only one spouse is involved in the business, but the other spouse has voting shares, 49% in some cases, that have half of the value of the business, and it's really being done to reduce taxes on sale, and no one's really thinking about the implications for family law purposes.
And as a family law lawyer, and ironically, I speak to a group of accountants usually once per year, and I try to tell them, I understand that you're doing this for tax purposes when you sell the business, but more times than not, the businesses don't sell at the kind of numbers that the ownership hopes for, and that the likelihood of that tax savings to me is a lot less important than the family law considerations that you take on. Because when you make your spouse a partner in your business, they are just that. They're now a partner in your business.
Right.
And now you're giving them power over your business. And when it comes time to buy them out of the business, you're buying them out, not necessarily at the date of separation value. You're buying them out at the date of the deal, because they have shares in the company. Right. And I always look back on it and think about it, that when I was going through my divorce, if my former spouse had been a lawyer, would I have wanted her as a partner in my business? And the answer is absolutely not. And I say that to people every day. Don't make your spouse a partner in your business. I see we have another question that came in about, they're mentioning a specific case, Tracy and intergenerational disputes. Or I don't know if you're familiar with that, Jordan.
I'm not familiar, Andrew. No.
Okay. So if the viewer wants to ask a more specific question about that case, please do. But I'm not that familiar with it off the top of my head. And if I hear the facts, I may understand better about what that case is about. But one of the biggest problems we get into is the causes of conflict. Now, what do you see as causes of conflict in family-owned businesses? And when I mean family-owned, instead of both spouses owning it, I'm going to say multi-generational owned businesses.
Yes. You know, the seeds of dissension that give rise to business disputes are not family specific. They're just based on human nature and human emotion. And I see it the same time over and over again. Typically, what happens often when a business is started is that there are three owners with equal shares and the compensation is equal, because at the beginning, there's no basis to distinguish. There's no history of performance. So we're all going to own the same. We're all going to share the same. Fast forward 5 years, and one of the three is the rock star, generating 90% of the revenue, and the others are contributing in ways that may not be measurable. And as soon as someone starts looking at their partner's contributions as being inferior to theirs, that's one seed of dissension. Because what happens is I'm doing 90% of the work and I'm sharing 66% of the profit with my other partners whose contributions I no longer value. So once that happens, and once people cease to look at each other as contributing on an equitable basis, often that's the beginning of the end. The other common thread I see sometimes is with companies where there's an active owner and a passive owner. You and I might start a business, Andrew, and at the beginning, you may, give me $1 million for your shares. But once you give me your $1 million, I don't need you anymore. You're still going to get your 50% of the profit, but 10 years later, the business is tremendously successful. Yes, your $1 million was helpful, but 10 years later, I don't need you for anything, but you're still my, legacy problem. And I'm resentful that you're getting half the profit when I'm doing all the work. So once you have those situations, whether they're in a family or not, they're the seeds of dissension.
Now, one of the issues I get into is when a child becomes a partner in the parent's business. So they start to take on shares. And we will give advice in terms of timing, because there's a significant difference in family law if they acquire their shares before marriage or after marriage.
Right.
If it's before marriage, the shares are worth what they're worth on the date of marriage, and that's it. If they're acquired after marriage, you get to exclude those shares from your net family property, which means the other spouse doesn't get anything for those shares. So in essence, it can be very favorable to receive your shares post-marriage rather than pre-marriage. But the other place we get into, and I always think of it this way, is about documentary disclosure. The moment a parent hires a child and makes them a partner in their business, that means when they split up, their child's spouse will have access to all the books and records of the business.
Right.
And I don't know if that's something that you see your clients being aware of at the time they're including their child in the business, that they're thinking, you mean I'm going to have to show my corporate financial statements and corporate tax returns and general ledger to my son or daughter's spouse?
Right. No, it's not considered. And often when the child is made an owner, often it's before the child has married. So those issues are not front and center at all. When it comes to disclosure, under corporate law, a shareholder has very minimal rights to disclosure as a shareholder. They may also be a director and have additional disclosure obligations. A shareholders agreement may provide enhanced disclosure, but in the context of a family law dispute, court can order even more disclosure.
And that's where the challenge is, because when I say that to people, they look at me quite shocked and surprised. But that's the reality of the situation. And you need to realize that the moment you do that, you're opening up the doors to do something. I know I wouldn't want, my children are far from being of the age of being married, but I certainly would not want my son-in-law or daughter-in-law to have access to my corporate records and see them ending up in a court record. but that's exactly what can happen the moment you make them a partner. And I'm a big believer in saying to people, when you're making a decision, it should be an informed decision. And I think quite frequently people are not necessarily thinking about that at the time they're bringing their children into the business.
Often when I'm in a spousal ownership scenario, I will recommend to, one of the spouses that is my client, that there are family implications and that they really should consult with a family lawyer such as yourself. And more often than not, that advice isn't taken because everyone's in the honeymoon stage and no one really seems to think about the family law consequences, or their assumption is family law is what it is. And I understand there'll be support obligations and division of assets and impact on matrimonial home, and it'll all work itself out, but they ignore the impact on the business.
Well, the interesting thing too is if you look at the Family Law Act, it defines what a domestic contract is. And I'm paraphrasing right now, but a domestic contract is an agreement between two spouses that is signed and witnessed and affects various areas of their life, one of them being financial.
Right.
And I've often said, to me, that sounds like a shareholders agreement if both spouses are parties to the shareholders agreement. And if it is a domestic contract, now it brings on the obligations of financial disclosure.
Right.
And what rights have you given up within that agreement? Because sometimes what happens is, I think the corporate lawyers are trying to be creative. So for example, they may decide that one spouse should receive 50% of the growth shares, but the other spouse has all the decision making because they're the ones that is working the business.
Right.
But then you may find out later on that when they separate,
right,
just like our question before, the spouse who has half the growth but none of the decision making brings an oppression remedy
right,
application and wants
right,
to participate in the decision making. So no matter how cute you think you may be at the time that you're doing one of these transactions,
right,
and you might think you're going to waive independent legal advice because your interests are aligned between two spouses, you really
right,
do need proper independent legal advice, have proper financial disclosure, and dot your I's and cross your T's, because if something goes wrong, it may
right.
go very wrong and you're increasing legal fees. I see there's another question. Is there an oppression remedy if a spouse has a minority interest in a partnership? I would think, I mean, this is more a question for you, Jordan, but I would think there's a big problem in that terminology.
Yeah, so the oppression remedy is conferred under the Ontario Business Corporations Act. It is available to corporations. If the structure of the business among the spouses is a partnership, you're governed by, in Ontario, the Ontario Partnerships Act, which does not have any type of oppression remedy. However, at common law, the concept of partnership imposes what we lawyers call fiduciary duties. So someone could argue that a fiduciary duty owed by one partner to another is, more powerful than an oppression remedy. It's just there's no statutory regime for it.
And in fact, if you're making a claim against your former spouse as having oppressive conduct, you may also be making a claim that they breached their fiduciary duty as a director or an officer to the company that you're both a shareholder in.
Correct.
I believe that there may be one more question coming in right now, and that probably be about all the time we have. I'm just waiting for that question to be shown to me right now, so I apologize for the delay. I see the producer is feverishly writing it down. Is there a question coming? Okay, there is a question coming, so that helps. So perhaps, Jordan, I'll ask you one last question unless the question comes up from the viewer, which is, what steps can you take in a business planning stage to mitigate some of the problems that we've discussed?
Well, I think the starting point is whether or not involving both spouses in the business from a business perspective makes sense. If the answer is no, then the only reason to do it would be for tax reasons. And if, as a result of either business considerations or tax considerations, there are advantages to having both spouses as partners in the business, then, you know, I think you move forward, but I think everyone needs to understand what the family law consequences are. Everyone needs to understand what should happen at the point of breakdown to mitigate the impact on the business. And it gives rise to some, maybe not a full-blown shareholders agreement, but some rules that are in writing that assist with planning for the future and the way you both spouses want the future to unfold today when everyone's happy.
Okay, I'm going to jump to the viewer's question right now before we wrap it up, which is, if a spouse has a general security agreement on a shareholder's loan and she can recover it because of pending litigation with the husband. So I would look at it, if I'm understanding this question properly, that if I have a shareholder's loan over a company, that it's an asset for the purposes of equalization of net family property. And if I'm the non-shareholder, but the money's owed to me, I'll have that asset recorded on my side of the NFP statement, providing it's a recoverable loan. And on the other side's ledger, when they own the business, the value of the business will be reduced by the amount of that loan. The interesting twist comes up if that loan is not recoverable or all of it isn't recoverable, and that becomes a valuation issue of how much to discount it by and potentially to discount it over time. But at the end of the day, as part of a global settlement, the shareholder's loan will probably end up moving over to the shareholder's side of the ledger, and they'll buy out that shareholder's loan, because you don't want to be sitting there waiting on a payment from your former spouse's company towards a loan. And you certainly don't want to be threatening the enforcement of the general security agreement, because you don't want their business to be harmed. If you're receiving spousal support or child support, you want it to continue. We are past the end of the show. So Jordan, I wanted to thank you for coming on the show. It's been a pleasure having you. And for anyone who's interested in learning more about Jordan Dolgin and his work, you can visit him at www.dpclaw.ca, which stands for Dolgin Professional Corporation. Jordan's an excellent corporate commercial lawyer that I've known for many years, and I use him for my own personal matters as well. The next Ask Andrew show is on March 9th at 1 p.m. If you have any requests or ideas about future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.
Thank you, Andrew. Appreciate the invitation. Nice show. Bye-bye.